Roland Mumford with Mumford.law. Can cops trick you into letting them in your home? Constructive entry is a legal theory that I want to discuss today. It came out of another video that I did previously about warrantless entries into homes. Have you ever heard of constructive entry? I would imagine most attorneys haven't, as well as police officers and citizens. It's a legal concept that could mean police entered your home without a warrant, but still legally, or maybe illegally. Are you confused? You're not alone. Let's break it down. In the United States, the Fourth Amendment protects you against unreasonable searches and seizures. That generally means police need a warrant to enter your home unless there's an exception, such as exigent circumstances. Is there a felony being committed? Is there evidence that evidence may be destroyed? Is there a felony being committed in the home? Is there an emergency situation, and so forth? What if the cops don't force their way in? What if you open the door? That's where constructive entry comes in. Constructive entry happens when law enforcement gains access to your home, not by kicking the door down, but by using deception, force, or coercion to get you to open and let them in. Here's the key legal idea. Even if the door wasn't physically broken, which is the common fact pattern that we see in many of the videos that we do, that entry might be considered constructive and possibly unconstitutional. Here's an example. Let's say officers knock and say, "Let us in or we'll get a warrant and bust your door down." If they don't have a warrant and don't have the legal grounds to get one, that might be coercion, not consent. There's a key case that discussed constructive entry. This was the case of the United States versus Phillips, Ninth Circuit, 1975. Officers surrounded a house and yelled that they had a warrant. The person inside came out, but it turned out they didn't actually have a warrant. That was absolutely fraudulent. The court ruled this was a constructive entry, meaning it counted as a search without a warrant and the evidence was suppressed. So even though no door was kicked in, it was still illegal. But not all trickery counts. If police ask politely and you let them in freely, you give consent, that's typically considered voluntary consent. Even if they don't mention, you can say no. They don't have to advise you that you don't have to let them in or what your rights are. The line is whether the behavior was coercive, threats, lies about having legal authority, or overwhelming pressure. Courts look at the totality of the circumstances. So, what should you do if police come to your door? Ask if they have a warrant. If they don't, you don't have to let them in. Be calm, be respectful, but you can say, "I don't give consent to any searches." If they force their way in without a warrant or emergency, your lawyer may be able to argue constructive entry and challenge anything that they found. That would be through a motion to suppress evidence. And they would be arguing that the illegal entry to your home, and if any evidence was found, would be fruit of the poisonous tree, a famous phrase coined by a U.S. Supreme Court justice. Understanding key legal terms like constructive entry isn't just for lawyers, it's for everyone, especially if it helps protect your rights. Now, we discussed United States versus Phillips a moment ago. I want to discuss that a little bit more. The Ninth Circuit considered whether police entry into a William Ross Phillips office building in Santa Monica unlawfully violated his Fourth Amendment rights, despite no forcible breaking of the door. A little bit of background about that case. Phillips was convicted of conspiring to distribute cocaine and heroin under 21 U-46 and possessing controlled substances with intent to distribute. Here are some facts regarding the investigation. Undercover agents bought narcotics from intermediaries. Degner and Carpenter were the individuals' names, who then called Phillips' office using his business card. Degner and Carpenter visited the building shortly thereafter, during which time narcotics activity was observed. This provided probable cause that Phillips was engaged in drug distribution. But the question surrounds the entry. Officers enlisted uniformed local police to knock on the door and announce that they were responding to a burglary investigation, a fabricated pretext, an absolute lie by the police. Once an occupant opened the door, undercover agents entered immediately behind them and arrested Phillips. The court's ruling on constructive entry or deceptive entry. Let's talk about that. The Ninth Circuit held that such entry carried out by deception without physical force is a ruse and not covered by the statutory criteria of breaking under the 18 U.S.C. 3109. However, because the entry relied on a false pretext, a made-up burglary, the court treated it as effectively coercive, rendering the entry unlawful. The court reversed Phillips' conviction, concluding the entry was illegal despite the lack of actual force. There were some very important implications out of this case. The decision is often cited as an early example of constructive entry, where police induce someone to admit them through misleading or coercive tactics, rather than blatantly breaking in. It illustrates that consent obtained via deception about legal authority or purpose may be invalid under the Fourth Amendment. Now, why does this matter? Even without forced entry, a home or office can be treated as if it were broken into if police knowingly mislead occupants. This constructive entry doctrine protects against consent obtained through lies or misrepresentations, not just physical force. Context on how this ruling compares to later courts' handling of deceptive entry or examples from other circuits is something else I want to talk about. Let's put United States v. Phillips, a case I just talked about, into context with other cases across the United States that have shaped the constructive entry and deceptive police tactics doctrines. Courts have taken different positions depending on whether the deception violates the Fourth Amendment or not. Another context to this is constructive entry and deception, how courts have ruled differently. Now, we talked about Phillips. That was a fake burglary to gain entry. But let's talk about United States versus, I'm not sure how to pronounce this, Van Eaton, Vaneaton. That was a Ninth Circuit case, 1995. Their constructive entry was not found by the court. The police had knocked on a motel door. The suspect opened the door. Officers arrested him standing in the doorway. Apparently, he had crossed the threshold. Courts held that since the suspect was standing in a public doorway, no entry occurred, so no violation. However, you still have the same rights in a motel room with a door closed, in a motel that is, the same as if you were in your home. There's lots of case law about that. I actually have a case about a bonding company that broke into the wrong motel room in Arkansas with police standing outside, and they went in and falsely detained my client, that is the bonding agent. And there's a video you can see on Mumford.law that Random Patriot did. The guy was just an absolute jerk. You should check that video out. So a key takeaway from this particular case was that constructive entry requires physical or functional entry into a private space, not just an arrest in a doorway. That is the key holding from that case. Another case, United States versus Jerez, Jerez. That's the Seventh Circuit, 1997. Constructive entry ruled unconstitutional in that case. The officers knocked on a motel room late at night. This is another motel room case, loudly and repeatedly with weapons drawn, and surrounded the exits. The occupant eventually opened the door. The court ruled the consent was coerced. That's a key word here, coerced, that it was not voluntary. The key takeaway from that case was that even psychological coercion or an overwhelming show of force can result in an unconstitutional entry under constructive entry doctrine. Another case, United States versus Carrion, Carrion. Fifth Circuit, 1974. There, deception was allowed. There, in this particular case, the undercover agents gained entry by pretending to be buyers in a drug deal. Once inside, they identified themselves and made arrests. Key takeaway from that? Courts have allowed deception in undercover operations, especially where entry wasn't forced or coerced. It's not always unconstitutional. Another interesting case, Illinois versus Perkins. That was a U.S. Supreme Court in 1990. Not a constructive entry case, but it related to deception. The court held that police deception is not always unconstitutional, especially in jailhouse interrogations where no coercion is used. Deception alone is not always illegal. It depends on the context and whether it overbears the subject's free will. So we've talked about these particular issues of constructive entry. That's fraud, coercion, deception, etc. And here's the takeaways. Constructive entry is about function over form. Did police gain access to a private space by tactics that undermine free consent? The issue of free consent is the hallmark to the theory of constructive entry. Courts differ in how much deception is allowed. The more coercive or misleading the conduct, the more likely a court will rule the entry unconstitutional. Thank you for your time. Please click like, share, and subscribe. Hope you have a great day.